She was reportedly charged by the public broadcaster for alleged negligence and bringing the public broadcaster into disrepute. The matter relates to the airing of a special assignment episode. The SABC had been interdicted from broadcasting. Let's take you there live now.
I think deal with the nub of it, yeah.
The charge sheet, you'll find at page 6 of the bundle of documents that I've shared with you. And the nub of it you'll find at page 7. And there you will find 3 charges. I begin with charge 1.
Yes.
Charge 1 is a failure to discharge your duty to the corporation. And it reads as follows. Notwithstanding a clear term of the relevant court order, and perhaps maybe I could just give some background check.
Yes,
so
sir. Please.
Because I think the parts that I'm not reading are the parts that are not that are relevant because they give the right preamble. The background is that the SABC was interdicted from airing a particular program on special assignment, and the interdict happened by way of an interim interdict that was granted on the 14th of September.
Was that an interdict by a private party?
By a private party.
Yes.
Which is essentially a private company. In view of the interdict, in the SABC was barred.
Can you just take me to the order itself, please?
The order itself, Chair. So there's quite a few. Chair, you'll remember that there was an interim order as well as a final order. The interim order appears at page 22.
That's an order given by Justice Wayner.
Yes, and perhaps, Chair, if I could, with your permission, I don't think that this is material. Because the company that sought the interdict, the ultimate objective was to protect its name. May I request that for the purpose of these proceedings, and may I also ask that you direct the media, in the event that the name comes out inadvertently, that the media be directed not to disclose the name, because part of the interdict is that to protect the proprietary interest of the said private institution.
Yes.
Chair, the interim order itself appears at page 22, and that is the one that you correctly pointed out was granted by Judge Wayner.
Okay, so I've read the interim order. It's of interim nature pending finalization.
And perhaps I should say that the actual order appears at page 24. I've attached both orders.
Yes.
One on the 14th of September and then the other one on the 15th of September. It seems to me that the later one of 15th September was essentially the same, except just curing what appeared to be a common error or typo. So
yes.
In essence, the order was granted on the 14th.
Yes, and that order was made final?
The order much later on was made final, but not before the
yeah, because it says if it's not made final, it gets discharged.
It gets
but
discharged.
Pending that, it's of effect.
So before it could be discharged,
yes,
you'll see the interim order was pending a lapse of 10 days or the institution of another claim for final relief. If you go to page 30, you will see that
summons was issued.
Summons was served, the result of which is that the interim order was to endure for a period after the action was dispensed with.
Yes.
So that's essentially the background, Chair. Now, against that background, so the composition of the SABC is that there's the news division, which focuses on news and current affairs. Special assignments, the exact program that was interdicted, resorts under the news program, and the DE in charge of that function is the employee that is before you. So,
sorry, the employee is in charge of?
So she's the GE in charge of news.
GE, that's
Group executive.
Yeah.
group
Executive.
executive. Thanks. So just to cut to the chase, did she have knowledge of the interim order?
Yes,
And the first allegation is, in spite of that, she breached the court order.
indeed.
Understand. That's the first charge, yes. The second charge?
So if you'd allow me, because
Yes.
there are nuances. So against that background, the charges are the following. Notwithstanding clear terms of the relevant court order and the self-explanatory content of the correspondence from Mr. Mwako on 26 October 2021, you, through your conduct or omission, intentionally, alternatively, grossly neglected to discharge your fiduciary responsibilities to the SABC by allowing and or causing to be allowed by the SABC News and Current Affairs Program team to broadcast, air and or publish the interdicted special assignment investigative report concerning, I will not say the name because that is what is confidential, but this is the private entity, in breach of the relevant court order. Your conduct or omission assisted and abetted a crime to be committed, namely contempt of court. Charge 2, failure to prevent the broadcasting, airing, publishing of an interdicted story. You failed and or grossly neglected to take reasonable steps from 14 September 2021 to 26 October to ensure that the SABC News and Current Affairs Program does not broadcast, air and or publish the said interdicted special assignment investigative report on S3, resulting in the broadcasting, airing and or publishing of the interdicted story on the 26th of October. Your aforesaid conduct resulted in the SABC breaching the terms of the court order dated 14 September 2021, thus being in contempt thereof. Your aforesaid conduct further exposes the SABC unnecessarily to potential civil criminal litigation and possibly financial damages. And the final charge is charge 3, which is bringing the name of the SABC into disrepute, airing an interdicted story. Considering your conduct as outlined in charges 1 and 2 above, your conduct has improperly brought the name of the SABC into disrepute with a possible reputational damage.
So
those are the charges.
The essence is there's a court order and you deliberately breached the court order.
Indeed.
In your capacity as an employee of the SABC, with the consequences that the SABC has now breached the court order.
With the numerous consequences.
Yes.
Yeah.
It's not, you say it doesn't augur well for rule of law.
What is at stake is the rule of law, is a possible damages claim. It's also
Did the SABC oppose the interim application
No.
for interdict?
No.
They considered...
There was an internal agreement that, given the issues, that there is no wisdom in opposing it. In fact,
So it was a considered decision not to oppose.
Indeed.
So what is the, if I may ask, what is the, what's the public interest in this matter?
Well, we didn't bring the application for public interest. We don't take a view that there is a public interest issue. This is simply a issue of an employee of the SABC having breached their fiduciary duties. And that breach has no bearing on public interest. In fact, even the entity in question, the entity that sought the court order, does not have a public interest side to it. It's a simple private entity, and there's no...
Well, it may or may not, because they may be harming, and I'm just speculating, maybe the investigation, the journalistic investigation demonstrated that their practices is adverse to the interests of consumers. I'm speculating, I haven't read the application.
Yeah.
But it's newsworthy. So the journalist says, look, I've got to expose this. The question is whether it's true is another matter, because they probably run to court to say it's not true, you haven't heard our side of the version, judge, interdict, because if we don't give the interdict, the prejudice will be overwhelming. That's probably what happened in court.
Yeah. And my view and my submission to that would be, if that be the test, pretty much everything that news publishes would be a public interest, because essentially what they are doing is giving us news that they believe are important. And that's not the test in this case. The test is not whether the issues of public interest are at stake. They are not. What the issue is a contractual issue. Because if you dilute and minimize the test to just that, it would mean that every charge pertaining to the GE for news would be in the public interest if that was the measure. And I'm submitting that is not the
But
measure.
as I understand the way the charges are formulated, the charges are formulated as an order of court. We
Yes.
must respect the order of court. Otherwise, it's
100%.
undermines ruling
100%.
the rule of law.
Yes.
Yes. Can I hear Mr. Mudley? Mr. Mudley, how does your client plead to the charges?
Chairperson, our client pleads not guilty to all the charges.
What is put into issue? Was there a court order?
Yes, Chairperson, we agree that there was a court order.
Did she have knowledge of the court order?
She had knowledge of the court order, correct.
And then she deliberately breaches it?
No, Chairperson, that's actually not the case at all. She actually complied with the court order, Chairperson. And we will lead evidence to show that in the bundle. She had no problem, no issue complying. In addition to that, she recommended that the repeat episode, and in the episode entitled Still Waiting, was to play on the set date that the episode in fact played. So she had
That's
no...
26th of October.
26th of October, correct, Chairperson. The first time that repeat episode played was on the 5th of October. Where the problem comes into play is that there was a discrepancy on the coding of the episode, Chairperson. And now that discrepancy does not fall within her jurisdiction. And in our evidence will prove that that discrepancy is not her fault, Chairperson. She at all times, she even disclosed it in a letter to the SABC on the 19th of November.
So just to understand, you say there was no deliberate breach of a court order.
Correct, Chairperson. No
I
deliberate.
understand your defense. So you plead not guilty.
Not guilty to all
Fair
the
enough.
charges,
So call
Chairperson.
your first witness.
Thank you. I'd like to call Mr. Vanara as my first witness.
So, Mr. Vanara, before you take the stand, I am duty bound in terms of the Labour Relations Act to ask the parties, have they tried to resolve the matter?
Well, I'm afraid we didn't have much of an opportunity, but I'm not even sure of the scope.
But invariably, matters of this nature, unfortunately, in my experience, it takes the parties further apart.
Yeah.
Mr. Roxo, you don't think we should spend 10 minutes to see if we can explore a resolution?
Thank you very much, Mr. Chairman. That is always something to be recommended, whether it's legislated for or not. We won't be wasting 3-4 days of evidence. So yes, I would like to meet with the representatives of the employer and explore that possibility. We will then report to you, obviously not what we discussed, because that will be privileged, but we will report to you whether there is a possibility or not. Then whether
Because it seems to me that once the employee says, look, there was no deliberate breach on my part, then there's scope to resolve the matter.
I intend to persuade them on that, Mr. Chairman, because in fact, just to amplify, if you look at the,
Because I infer from that she accepts that there's a court order, I'll abide by it.
yes,
And I'm saying that to the best of my belief and knowledge, I did not intend to breach the court order. Once that's the defense and that's correct, then it seems to me there's scope to resolve the matter.
scope for that. Also further, Mr. Chairman, something which we have not mentioned, if you look at page 7 of the charges, if you look at charge 1, the last 2 lines of charge 1, your conduct and omission assisted and abetted the crime of contempt of court. The second one says that we expose them to damages. And the third charge, reputational damages. Now, that has no foundation. I want to persuade my friend that has no foundation, because by the time these charges were proffered, the court case which led to the interdict, the actual summons. So there was an interdict, and the judge insisted that the interim interdict could only stand if a summons was issued. It was, and before the 25th of November, that matter had been fully and finally settled between the lawyers for the SABC and the lawyers for that private company, where they had said, we have no more claims against you. And so we find it extremely strange that a month later, And it's part of your papers, the settlement.
But is he not saying it had the potential?
Mr. Chairman, one of the points we want to argue is something which is fundamental in law. Damages is a question of facts. It's not a question of reputational damage, is a question of fact. Damages for this there was no possibility of any contempt of court because the matter had been fully and finally settled. So
that is between the applicant that brought the interdict and the summons and the corporation.
The corporation, and there's a settlement agreement signed by both parties, which was made an order of court or is about to be made an order of court, but because of case lines it hasn't been stayed. But it's common cause that had gone. This is what we find extremely strange, is whereas the first part of the charge sheet is up to debate, but there are no consequences. Nothing happened. No one was charged for contempt of court. No one was sued for damages, and no one was sued for reputational damages because that had gone away by the time. In fact, exactly a month before, that had gone away. So we find it extremely strange how this finds its way here. Because, Mr. Chairman, if you then read the balance of that, it's easy to deal with the basic allegations of the charge sheet if you exclude, which you have to exclude because it was no longer there. And that I intend to persuade the SABC lawyers that this is a waste of time. That and openly engage them in debate. That is a very serious omission from the charge sheet to allege things which are not possible. Because we're going to waste our time dealing with the consequences. There were no consequences. There will be no consequences in view of the full and final settlement and the withdrawal of that matter. It's no longer on record.
So can I ask you parties then to see if you can resolve the matter? If you can't, then we continue.
Yeah. And what is your guidance as to time?
Whatever time you need.
We will then approach you.
Yeah.
Thank you.
So you've got independent breakaway rooms and just retire to it. So I shall direct, Mr. Bill, I shall direct the parties to try and find one.
That's perfect. Thank you.
Thank you, Mr. Chairman. May you be excused.
Second. In the meanwhile, you want me to read the bundles? I can read your bundle.
I would welcome that. Thank you.
And have you got a bundle?
Yes, we do, Chair.
I'll read that in the interim. Thank you.
Well, there you have it. That's the first interaction. Ms. Magopeni pleading not guilty to all the charges that have been put to her and saying that she complied with the court order. Of course, we'll continue to give you all the detail that comes out of there. Let's take a break.